Brought to you by 4D Termination, Incorporated, empowering non-custodial parents and strengthening families. Brought to you by 4D Termination, Incorporated, Educational Information Services, the non-custodial advocates. The information contained in this video is provided for informational purposes only and should not be construed as legal advice on any subject matter.
Ready hearing?
Yes. I was calling to check on the status of a request letter for information.
Okay, what is your OAH number?
Hold on, give me a second. I have to look that up. Can you look me up on my social security number or anything like that?
I can try that.
Okay, my social security number.
What's your name?
My first name is Tynan and my last name is Bill.
Okay, how can I help you?
I sent in an FOIA that requested information that through the email to four of the court clerks that were listed on the website, and I was wanting to see if you guys had received those.
I don't recall seeing that your name. What was the request exactly?
It was for some court documents that were supposed to be filed with the Oklahoma District Court, for a child support case.
What documents? Did you specifically tell us which documents you needed?
I needed the proof of process service for the child support lien, like a notice of pendency action that has the legal description of the property that the lien is against. And I was needing proof of service or process that gave me notice for the child support administrative hearing that held me in default.
You're going to need to send us that in writing with a self-addressed stamped envelope so we can send you that copy.
Can you give me the right address that I need to send to it?
Yes. Are you ready?
Yeah.
Okay. P.O. Box.
Okay.
25352.
Okay.
Oklahoma City.
All right.
73125.
Okay.
And make sure you address it to Office of Administrative Hearings.
Gotcha.
When you look up your case log, you'll know how much postage to put.
Okay.
You said you wanted... Okay, you might have to tell me again.
The proof of process service for the administrative hearing on February.
You know about the date because we don't have any documents.
Yeah, the date was September 10th of 2012.
Okay, so affidavit of service.
And
okay, that's only one page, so you're good there.
And then there's another one for the notice of pendency action for the child support lien. And then on that.
What's the date on that one?
It's the same date.
Okay.
But I was wanting.
I don't have any calls. I have for that date is an administrative order and the affidavit of service.
So you don't even have the proof of process of service where I was notified?
That would be the affidavit of service.
Is that for the administrative hearing? Or is that for the...
Yes.
Is that for the enforcement order?
Let's see. You were served in person on the 2nd day of August of 2012 with the following address. For the annual notice and notice of enforcement proceeding and notice of intent to suspend or revoke licenses. So it shows that you were served for all of those.
What address is that?
1732 Southwest Boulevard.
1732 Southwest Boulevard. How was that served to you? By certified mail?
Let's see. I don't see. It's the affidavit of service. It doesn't say anything else.
And
it says it was delivered to you on August 2nd of 2012.
Could you repeat that address one more time that you said that they served me at?
1732 Southwest Boulevard, Tulsa, Oklahoma.
1732 Southwest Boulevard.
Mm-hmm.
Okay, let me think of something else. I got you on the phone here. And you said it doesn't say anything about being served by certified mail?
I don't see anything. It just says it was that you were served in person on the 2nd day of August of 2012 at the following address. 1732 Southwest Boulevard, Tulsa, Oklahoma.
1732 Southwest Boulevard.
1732 Southwest Boulevard. I don't think I remember living at that address, yet alone being served a summons to appear for a child support enforcement hearing. Where is 1732 Southwest Boulevard, Tulsa, Oklahoma? It says here that 1732 Southwest Boulevard is a place of business. It's a law office. The Office of Administrative Hearings Court Clerk is saying that I was served in person here. So who are the law offices that are in this building? It says we have Brian Smith and Associates, Brian Smith and Associates Incorporated, Bulldog Divorce, and Daniels and Thompson. Remind you that I have never been to this building and I don't associate with these people. So where is even the chance that I could be served in person here at this address? So we're going to focus on Brian Smith and Associates. So who is Brian Smith and Associates? Brian Smith is a process server. Says they've been in process serving since 1980 and that he's licensed and bonded and that they serve legal documents statewide and nationwide. So as we scroll down the page, we're going to come across the address for Brian Smith and Associates. The address for this processing company is 1732 Southwest Boulevard, Tulsa, Oklahoma, which is the same address that the Office of Administrative Hearings is saying that I was served in person for the enforcement order. So this is a newspaper article for the Tulsa World newspaper. They were interviewing Brian Smith. The question that they asked him was, what's a difficult assignment that is in the process serving business? He goes on to tell a story about serving a woman who lived in Tulsa County, but the case was filed against her in Creek County. He clearly stated that because the case was filed in Creek County, she had to be served in Creek County. She may live in Tulsa County, but because the case was filed in Creek County, he had to serve her in Creek County. So he goes on to explain about how he can find her in Creek County because he cannot serve her in Tulsa County because that is not where the case was filed. The girl was a teenager that was involved in a car wreck, and they figured that since she was a teenager that she probably went to one of the high schools that were located in Creek County. So they waited in the school parking lots of these high schools that were located in Creek County until they found her car. Said from there that all they had to do was wait for the right time. So even though that he's licensed to serve process in the city of Oklahoma, and the fact that she lived in Tulsa County, he still wasn't able to serve her in Tulsa County. He would need to serve her in Creek County because that is where the case was filed against her. So let's apply that scenario to my case. My child support case was filed against me in Okmulgee County, and I live in Tulsa County. So just like this girl, he would have to serve me in Okmulgee County and not Tulsa County. So not only is it impossible for him to serve me in Tulsa County, but it's also impossible for him to serve me in person, which is said to be at his place of business. So with these facts being said, there's no way that he served me in person. Says that he should know because he comes from a family with strong legal ties. So it's proven that I was never served notice of process. What now? So what happens if you were never served? If you have not been properly served and you do not show up, the court has no personal jurisdiction over you and you can't enter a judgment against you. The case can be continued to another court date and the other side can try to serve you again. But hey, that was 2012 and this is 2021. That was 9 years ago and they've never tried to serve me again. So if a Google search is not good enough, then let's take a look at what an attorney has to say about it. So someone was on here, they were asking lawyers for a specific question. They said they were never served and a default judgment was granted against them in 2011. Can they have it dismissed for improper service? Says when a creditor files suit and then files a motion for a default judgment, the judge generally checks to be sure that the creditor did get service on the defendant. She goes on to tell this person that they need to check their case docket to make sure that they were not properly served before taking any action to get the case dismissed. So at the very bottom of this paragraph, she states, if they truly did not get service, then yes, you would be in position to dismiss the order. So now let's be logical and ask the real question. So knowing that I was not served, can the child support enforcement and lien order be valid and enforceable? To get the answer to that question, we have to go back to this. If you have not been properly served and you do not show up, the court has no personal jurisdiction over you. So without that personal jurisdiction, they can't enter a judgment against you. So no, the order cannot be valid and it cannot be enforceable. So let's take a look at my order and case docket to take a look at the unenforceable acts that they committed against me illegally. What we're looking at here is the enforcement order for my child support case. This is the order for enforcement, and this is also the order for the child support lien. They were also trying to suspend my driver's license, but that was already suspended. So let's just focus on the enforcement and the child support lien. So this is my court docket for my child support case. We are going to focus on September 11th, 2012, the administrative order. See how there is no affidavit of service filed beforehand? This is where the affidavit of service that says that I was served at 1732 Southwest Boulevard is supposed to be filed right before this administrative order. So who is supposed to acknowledge the proper service of process before signing the default judgment? Let's take a look at that attorney answer again. She states, the judge generally checks to be sure that the creditor did get service on the defendant. So the administrative law judge, Carla D. Haddix, was supposed to acknowledge the proper service of process before signing my default judgment for failure to appear. Well, I can tell you more than likely she acknowledged it, but signed the default order anyways. You see, there is a backstory before my child support case even started with Carla D. Haddix. She is best friends with my son's mother. They both used to work for the child support agency for the county of Okmulgee. My son's mother's mother was manipulating and bullying and blackmailing and taking advantage of my son's mother. She was taking advantage of her Social Security benefits, so I reported her to the Social Security Administration. And when the Social Security Administration got in contact with her, it started a war. One of her ways of retaliation for this was to put me on child support so that way that I would end up in jail. She and Carla both planned on putting me on child support. This was planned a whole year before I was even summoned to come in and take a paternity test for my son. Fortunately, I did get it recorded for the world to hear.
That'll be a wrap. That'll be a wrap. I could do it easy. But he's telling you that I can't. They take it serious. They suspend your license, then they throw your ass in jail. I know. I used to work Termination. I know what I'm talking about. Always serious, man. And you're going to pay that child support. Because all you got to do is go to Judge Pickering and get a letter signed. And that'll be a wrap. That'll be a wrap. I could do it easy. But he's telling you that I can't. They take it serious. They suspend your license, then they throw your ass in jail. I know. I used to work Termination. I know what I'm talking about.
So now we're going to talk about a judge's oath, canon law, the abuse of process, malicious prosecution, improper purpose, and favorable judgment for the plaintiff. Section 1 of Article 14 of the Oklahoma Constitution is where you can find the judge's oath. The main part of the oath that we want to focus on is that they pledge to obey and defend the Constitution of the United States. Not just the Constitution of the United States, but the Constitution of the state of Oklahoma. So another thing we need to look at is canon law. So we're going to be looking at Rule 2.2, Rule 2.3, Rule 2.4, Rule 2.5, Rule 2.6, and Rule 2.9. Okay, so looking at Rule 2.2, this has to do with impartiality and fairness. It says a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. The administrative law judge, Carla D. Haddix, did not perform her duties of judicial office fairly. So she is in violation of Rule 2.2. The next rule we're going to look at is Rule 2.3, which is in regards to bias, prejudice, and harassment. Section A of Rule 2.3 states that a judge shall perform the duties of judicial office, including administrative duties, without bias or prejudice. The administrative law judge, Carla D. Haddix, is considered to be biased because she is best friends with the custodial parent's mother. So in Rule 2.4, we're looking at the external influences on judicial conduct. Basically, this rule is telling us that they are not allowed to administer court decisions based on the influence of an outside source, such as a family member or a friend or someone on the outside source. The administrative law judge, Carla D. Haddix, is in violation of Rule 2.4 because she allowed the dispute between myself and Kimberly Stokely to influence her decision. Rule 2.5 refers to competence, diligence, and cooperation. The administrative law judge, Carla D. Haddix, is in violation of Rule 2.5 because she did not perform judicial and administrative duties with diligence. She performed these actions by fraud. Now we're going to be taking a look at Rule 2.6, which is ensuring the right to be heard. Because there was no service of process, and because the administrative law judge, Carla D. Haddix, failed to acknowledge that the address that was on the affidavit of service was not correct, she is in violation of this rule. And last, this is Rule 2.9, which refers to ex parte communications. It says that a judge must not get involved except if she believes that no party will gain a procedural, substantial, or tactical advantage as a result of the ex parte communication. The administrative law judge, Carla D. Haddix, is in violation of this rule because she knew that there was a substantial gain from the influence of her outside source. She had all the acknowledgement to believe. So what we have here now is a malicious prosecution and abuse of process. Says a plaintiff can sue for abuse of process when a defendant starts legal proceedings with the intention of obtaining results for which the process was not designed. While on the other hand, says that a plaintiff can sue for malicious prosecution when a defendant maliciously prosecutes a criminal case or uses civil proceeding against the plaintiff when the defendant knows he or she doesn't have a case. But this only applies if the plaintiff was granted a favorable decision before the defendant can sue for malicious prosecution. The administrative law judge, Carla D. Haddix, is guilty of malicious prosecution. So the main reason why I kept getting warrants and kept going to jail behind my child support was because not that I wasn't making payments, but because I lived 45 miles away for where my child support case was established, and I don't have reliable transportation. So with the lack of transportation being said, not only could I not make it to my child support court, but I also had trouble getting in and keeping a job. But whenever I did get a job, my child support payments were garnished, and that is considered as a payment. But let's not forget the fact that I was not served for this enforcement order. So, for the last 9 years, they have been illegally forcing me to pay and garnishing my checks and taking my tax refunds. But not just taking my income. What about the fact that they were issuing bench warrants and giving me contempt and keeping me in jail? Since this order is not enforceable because they did not serve me notice of this order, then wouldn't these things be considered as wrongful conviction? So what are the 6 causes for wrongful convictions? While there are 6, the only 2 I'm going to focus on are false confessions or admissions and government misconduct. So if my conviction is found wrong, can I get paid for it? It says here that in the state of Oklahoma, that a wrongly convicted person is entitled to receive $175,000 for the entirety of his wrongful incarceration, but that's only if he did not plead guilty. This is the only document that I pled guilty to, and it was only because I was incarcerated and my court-appointed attorney had told me that either that I could plead guilty and sign this document or be sentenced to 6 months in jail for contempt. So this purge agreement was signed under duress and coercion, not to mention the verbal threat of jail time if I didn't sign. But we still have to remember that there is no service of process for this agreement to even need to be signed. The whole closure of my case is going to revolve around the failure of service of process. The extra stuff is what I'm throwing in to expose the fraud for what it really is. So going through the video so far, we found out there is a lot of judicial misconduct going on with my child support order, and my rights are being deprived behind it. What can I do about it? For the judicial misconduct, the Oklahoma Council on Judicial Complaints is where you would file a complaint for judicial misconduct that is against a judge. And here is a copy of that complaint form. So as we discussed in the other video that is titled The Single and Separate Unit, we learned that these people are not of the state and that they are acting under color of law. You would need to gather this evidence and file a Section 242 Title 18 lawsuit for deprivation of rights under color of law. You will need to file the lawsuit against them by their names and not by their job titles, which is considered as their individual capacity. So if any of this pertains to your case, do you need to draft a motion to dismiss? LawShelf.com has a well-written and persuasive drafting to a motion to dismiss. They have a 20-minute video that teaches you how to draft your own motion to dismiss and make it well-written and persuasive. So that wraps up this video, and I hope you guys enjoyed watching it. I hope this video helps someone with their situation. Brought to you by and edited and produced by me, Tiny Drew Deal, with 4D Termination Incorporated. We are 4D Termination Incorporated, the non-custodial parents advocates, and we are here to empower non-custodial parents and strengthen families. So if you liked what you watched, go ahead and hit that like button and the subscribe button to subscribe to this channel. And thank you for your support.